Eek, 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 eek. Welcome, Ospreys, and welcome everybody to McDuff Lives 1 and McDuff Lives 3, broadcasting today, and also on McDuff channel on Facebook, where we are starting to expand our presence over there at Facebook. My friends there are starting to pass around the link, so perhaps we'll start getting a crowd at Facebook. That would be cool, in addition to our friends here at YouTube. And we are broadcasting on two of our three channels this morning because we always keep one in reserve in case we get those notorious strikes, the YouTube channel strikes. Oh my God. Well, one way to avoid YouTube channel strikes is to have three channels, and that's what I've done. I've just had to do it. Same as Mark Kulak's done. He got a strike yesterday for his reporting on uh, in what he sees coming as a RSV approach towards jabs, so that the next thing will be to try to get to uh, pregnant women and children on the theory that we need to prevent RSV, the syncytial virus thing that's apparently quite easily defeated by very young children, and something that's not a matter of life and death, but it's like a bad cold or lung infection of some kind. I don't know, RSV. So that was his reporting, and they struck him down for that. So that means he's over the target as usual. When they strike you down, that means you are hitting them where it hurts. And whether he's right about that or not, they are certainly not willing to allow his theories to be popularly circulated. So we have to do it for him. So everybody remember, Housatonic uh, its.com is where to get his website, and check out all three of his channels, because he's being forced to play the shell game, same as we are here at McDuff Lives. So welcome, and thank you for being with me for a Friday live chat. I enjoy this because usually by Friday my brain is pretty fried, and I wouldn't want to have to come up with a whole concept of a show for you today. Had a wonderful week, and looking forward to talking to you about the latest and greatest news around the world, whatever is on your mind. What is on my mind, of course, is wow, the Supreme Court opinion. And the first thing I want to do is turn to Politico.com, who were kind enough to publish the opinion. I just started reading the syllabus before the show, and I'm going to go over there now and share it with you so we can see if we can read it together. Let me maximize that screen. And let's see here. Here we go. All right. Now let's see if I can share this for you. It's called the Dobbs decision. All right. And I'm just going to highlight some of the syllabus for you. I've already read about the first 2 pages. That's all I've done. But I think this is a very, very crucial, important decision that is going to resonate for, in the halls of courtrooms and justices and everybody for a long time. This is a big, big deal. All right. Dobbs, state health officer of the Mississippi Department of Health et al. Versus Jackson Women's Health Organization et al. And from the Fifth Circuit, Mississippi's Gestational Age Act provides that, quote, an exception in a medical emergency or in the case of a severe fetal abnormality, a person shall not intentionally or knowingly perform or induce an abortion of an unborn human being if the probable gestational age of the unborn human being has been determined to be greater than 15 weeks, unquote. Okay, so the Roe versus Wade standard is, I think, 24 weeks, and this was um, too short a time for the pro abortion side, and just about right for the folks that are generally anti-abortion, but obviously they're not so anti-abortion, not as to allow abortion in the first 15 weeks. So it was a kind of a narrow issue of how many weeks is okay, but the court decided to use it to strike down Roe versus Wade, and specifically the idea of a constitutional right to an abortion. And let us, at the outset, recognize that as our health care law has developed under the present um, research pandemic, whatever you want to call it, um, sorry for that, but it's uh, it's really hard to describe what it is. But what's happened is that the individual states have become the authorities for health procedures. And that follows the idea that the 10th Amendment says that all powers not specifically enumerated herein are reserved to the states and to the people, or to the people, if I recall. So that is the backdrop in which we find ourselves reading this opinion today on June the 24th of 2022. It's a Friday, and that's no coincidence, right? They do the big drops on Fridays. But what's at stake here besides the time limits of 15 weeks to 24 weeks? Is there some reason they couldn't have compromised that, or why is the Supreme Court making such a big watershed announcement, even preceded by a drum roll of a leak, just to let everybody know it was coming? I mean, this is political manipulation of the public by that leak, of course, and it diminishes the authority and the respect that we have for a Supreme Court that can't keep its own secrets. Okay, here's the holding. It says, held, the Constitution does not confer a right to abortion. Roe and Casey are overruled, and the authority to regulate abortion is returned to the people and their elected representatives. The critical question is whether the Constitution, properly understood, confers a right to obtain an abortion. Notice they don't say in any particular time limit. They're just saying generally, at any time, does the Constitution give you the right to get an abortion? Casey's controlling opinion skipped over that question and reaffirmed Roe solely on the basis of stare decisis, means that it's already been decided and it stands decided. Um, and that's an important concept in our constitutional law. Stare decisis is the default. You don't win by going against a already decided decision unless you can do as they've done in this case, overcome the rationale of that decision so strongly that a new Supreme Court decision has to come out and actually overrules the decision that was so binding on so many courts and plaintiffs and juries and defendants over decades. Well, here we are in that situation where 50 years of law is getting set aside in one day. Casey's controlling opinion skipped over that. A proper application of stare decisis, however, requires an assessment of the strength of the grounds on which Roe was based. The court therefore turns to the question that the Casey plurality did not consider. First, the court reviews the standard that the court's cases have used to determine whether 14th Amendment's reference to liberty protects a particular right. Okay, that's important. The court is saying First, we're going to look at the standard that the court's cases have used to decide whether the 14th Amendment, which is where the right of privacy comes from, according to Griswold versus Connecticut and Justice Douglas and the liberal court of the 60s. In that protection of liberty, the Supreme Court has a procedure that it has used to determine whether a particular right falls within the protection of liberty. Okay? So you can't just say my 14th Amendment gives me the right to do whatever I want to, because that might not be something that's considered to be a particular right that liberty protects. Okay, it's fair enough. The Constitution makes no express reference to a right to obtain an abortion, but several provisions have been offered to as potential homes for an implicit right. Okay, and that's what they did in the 60s, was to make an implicit right out of other provisions. Okay, part two. This is where I think we need to have a very, very focused discussion about what does this mean. Okay. Next, the court examines whether the right to obtain an abortion is rooted in the nation's history and tradition, and whether it is an essential component of, quote, ordered liberty, unquote. The court finds that the right to abortion is not deeply rooted in the nation's history and tradition. The underlying theory on which Casey rested, that the 14th Amendment's due process clause provides substantive as well as procedural protection for, quote, liberty, unquote, has long been controversial. Okay. In other words, does the 14th Amendment protect my rights that are guaranteed in the Bill of Rights? Okay. They're going to go over that with a fine-tooth comb and decide what particular rights are part of, quote, ordered liberty. Now, that should be a big speed bump for us when we see the Supreme Court talking reverently about this concept that I've never really run into, at least not in a Supreme Court decision, called ordered liberty. Okay? I don't mind if I don't have a constitutional right to, do something extraordinary that I want to do, but the Constitution, doesn't protect my right to do it. A local law might say you can't do that. Maybe I want to go swimming in a particular creek, and the local law says no, you can't do that. Well, I want to. I'm a free person, and I'm just making this up as I go along, but trying to think of an exercise that we could go through together to decide whether it's part of, quote, ordered liberty, or is it just my own personal fancy of what I want to do and call that liberty. The court's decisions have held that the Due Process Clause protects two categories of substantive rights: those rights guaranteed by the first 8 amendments to the Constitution, and those rights deemed fundamental that are not mentioned anywhere in the Constitution. In deciding whether a right falls into either of these categories, the question is whether the right is, quote, deeply rooted in our history and tradition, and whether it is essential to the nation's, quote, scheme of ordered liberty, unquote. Quoting a case, Timms versus Indiana, and I have to say I haven't kept up on Supreme Court law, so I'm not familiar with that case. The term, quote, liberty alone provides little guidance. Oh, you know what? I think Jefferson found the word liberty to be quite sufficient. And don't you? I mean, liberty is liberty. See, this is where we were talking about Adams and Jefferson yesterday, Really, Adams is an ordered liberty guy, and Jefferson is a real liberty guy, and that tension has existed in our country ever since the founding fathers. But here we have the imposition, and I keep seeing Attorney General Barr, like the froggy face, saying, "I will make the decision of what is ordered liberty," and that's what the Justice Department is for, the Just Us Department. They get to decide these things, and it might say somewhere that you can do something, but it's really up to the wise people that sit at the top of the justice pantheon. All right, that was me editorializing, and let's get back to the decision. Historical inquiries are essential whenever the court is asked to recognize a new component of the liberty interest protected by the Due Process Clause. In interpreting what is meant by liberty, the court must guard against the natural human tendency to confuse what the 14th Amendment protects with the court's own ardent views about the liberty that Americans should enjoy. What? What? You mean liberty isn't really liberty? You have to have 14th Amendment liberty is different from liberty. Okay? That's what I just read. For this reason, the court has been, quote, reluctant to recognize rights that are not mentioned in the Constitution. Guided by the history and tradition that map the essential components of the nation's concept of ordered liberty, there's that phrase again, the court finds the 14th Amendment clearly does not protect the right to an abortion. And then he goes on and says, that abortions were criminal crimes in most of the states, until the latter part of the 20th century. Indeed, abortion had long been a crime in every state. At common law, abortion was criminal at least some stages of pregnancy, and was regarded as unlawful and could have very serious consequences at all stages. Well, American law followed the common law until a wave of statutory restrictions in the 1800s expanded criminal liability for abortions. By the time the 14th Amendment was adopted, three-quarters of the states had made abortion a crime at any stage of pregnancy. This consensus endured until the day Roe was decided. Roe either ignored or misstated this history, and Casey declined to reconsider Roe's faulty historical analysis. Instead of seriously pressing the argument that abortion right itself has deep roots, supporters of Roe and Casey contend that the abortion right is an integral part of a broader entrenched right. Okay, pay attention here, guys. Roe termed this the right to privacy. Okay, it's just what it's really at stake here. It's not between 14 and 24 weeks. It is whether or not we have a constitutional right to privacy or not. Why is it important to have a right to privacy? Because of the doctor-patient privilege. Privilege, private, privacy, doctor. What do I need to inject, if anything, in my arm, doctor? Well, that's private. You and I, we don't discuss that outside of the doctor's office. That is personal, private, protected information based upon what? Well, we do have a doctor-patient privilege from the common law that is protected in courts. However, I don't know about you, but I find it very, very harder and harder to find a doctor to treat me, and I'm getting treated by, nurse practitioners. But more importantly, as Mark Kulak has pointed out, and others have pointed out, our medical system is being driven by scientists and not by doctors. So their interest is in statistics. Their interest is in results. They don't want you to have a right of privacy because they want to see your medical records. And this whole idea of universal health care or a worldwide health system is a very convenient avenue for the scientists to gather data from millions and billions of people. I'm not saying there's anything wrong with it, but I think we do have to sit, get up, stand up. Do you want your medical information to be publicly available to anybody that wants to check on you? Do you want your medical information part of a decision-making process as to who does or does not need to have certain medications, or who is going to be on a restricted travel list, or who can be in the army, or anything? Do you give up your right to medical privacy? Because there, you see, is where the current situation lies. Are we, in this abortion decision, being told that, if you don't have a specific right to resist a medical treatment because the court has decided that this right of privacy doesn't exist? All right, I haven't read the decision. I'm not done yet, but that's what concerns me. Ordered liberty sets limits and defines the boundary between competing interests. Roe and Casey each struck a particular balance between the interests of a woman who wants an abortion and the interests of what they termed, quote, potential life. But the people of the various states may evaluate those interests differently. The nation's historical understanding of ordered liberty does not prevent the people's elected representatives from deciding how abortion should be regulated. So this is the other thing: is don't think that people are not allowed to have abortions just because of this decision. What this decision says is that the representatives of the people in their state legislatures are quite competent to make the decision on behalf of the people of the state. So, in a sense, it does re-empower the voters, because while you can't vote for a national abortion standard, Democrats for 36 and Republicans for 14, and fight it out on that basis. I think in a way, it's a good thing, because now local people are going to have to get involved in the fight. If you're in a state where you think that the abortion is too permissive, well, you know where to make your complaint. It's not in Washington at the Supreme Court anymore. It is at your local state legislature, executive, and local judicial system, which is going to have to figure out how they, in their state, are going to follow this decision. Okay, now the nature of the court's error. This is what's wrong with Roe versus Wade. The nature of the court's error, like the infamous decision in Plessy versus Ferguson, which, if you don't know, that was the big decision that said that segregation was okay because the states were providing separate but equal facilities, which everybody knows was not true. Roe was also egregiously wrong and on a collision course with the Constitution from the day it was decided. Casey perpetuated its errors, calling both sides of the national controversy to resolve their debate. But in doing so, Casey necessarily declared a winning side. Those on the losing side, those who sought to advance the state's interest in fetal life, could no longer seek to persuade their elected representatives to adopt policies consistent with their views. The court short circuited the democratic process by closing it to the large number of Americans who disagreed with Roe. Well, that is as far as I was able to sketch out this morning just before the show. Of course, the opinion was just issued and just printed, and glad to have the opportunity to go through the syllabus, at least some of it with you. Here's the end of it here. Abortion presents a profound moral question. The Constitution does not prohibit the citizens of each state from regulating or prohibiting abortion. Roe and Casey arrogated that authority. The court overrules those decisions and returns that authority to the people and their elected representatives. Now let's see. Alito delivered the opinion in which Thomas, Gorsuch, Kavanaugh, and Barrett joined. Thomas and Kavanaugh filed concurring opinions. Roberts filed an opinion concurring in the judgment, and he's the one that's kind of suspected of leaking it, right? Breyer, Sotomayor, and Kagan filed a dissenting opinion. Well, enough from that to fuel the rest of the discussion this morning, if that's where you guys want to go, or we can talk about anything you'd like to. I'm going to take a moment and say hello to the chat room. Hello, chat room. Hello, Barbara, Corky, Laura, and Jimmy, Kathleen, Nadia, Barbara Kay, and Greg Clark is here. Captain Gertrude, Leslie, and Kathleen Barnes is here. Thanks for everybody for joining us here at McDuff Lives. We have 71 viewers according to the current count. And now I'll see if anybody has any comments that they, let's see. The result of a shotgun wedding, I guess, Mike. Glad you're here. Yeah, you never know. You never know how these things, so many stories never told. Kathleen Barnes says your insurance company has access to your medical records. They're the ones paying, so there really is no privacy. Isn't that it's true as far as that's concerned. And, if you want to pursue anything legally, you're going to end up signing away a medical authorization. But the HIPAA Act does offer a lot of protection against misuse of your records. So it's not like they can do anything they want. And that, boy, you point out what is really another whole aspect of it is now look that the Supreme Court is saying that, this moral decision, which, is a medical decision, is now within the power of the people of any state within the union to decide. What's that going to do to health insurance? Because if it's the same result with regard to other medical procedures, are you going to have states involving different procedures to see who gets a transplant? Who's on the kidney list? If you have a history of drug abuse, are you still going to be able to get on the transplant list? If a state decides to do something, drastic, like, a complete ban of abortion, like was the law back in before Roe versus Wade in many states, as we just read. Is there any recourse at all? Will the state constitutions be available to fight against the state law? Each state now is going to be its own medical procedure dominion. And I think that's going to be a big, big problem for health insurance and the idea of universal health care. This is a big, big monkey wrench. Oh, hi, Leslie. Liberty means not in jail. Quote from Joni Mitchell. Okay. Yeah, I like that. Sounds kind of like Janis Joplin too. But this concept of ordered liberty is a that I don't like that. I don't like that at all. I'm going to just Google it and see what I come up with. Ordered. Okay. Just a little research here while we're in the middle of the show because I'm fascinated with this concept. Ordered encyclopedia.com, just to open the very first entry here. Ordered liberty, a loosely used term diversely applied in scholarly literature and judicial opinions. Ordered liberty suggests that fundamental constitutional rights are not absolute, but are determined by a balancing of the public, that is, societal welfare, against individual personal rights. In this dialectical perspective, dialectic, right? The thesis is, quote, order. Its antithesis is liberty. The synthesis, ordered liberty, describes a polity that has reconciled the conflicting demands of public order and personal freedom. Justice Benjamin N. Cardozo, very famous liberal justice, majority opinion for the court in Palco versus Connecticut of 1937, provided what was probably the first judicial recognition of ordered liberty. Acknowledging the difficulty of achieving, quote, proper order and coherence, Cardozo identified some constitutionally enumerated rights that were not of the essence of a scheme of ordered liberty and thus not incorporated in the 14th Amendment and applied to the states. This is what the Supreme Court opinion was just talking about. So that there's some parts of liberty. Okay, this 1937, here's the root of it. To abolish, let's see, quote, to abolish these rights is not to violate a principle of justice so rooted in the traditions and conscience of our people as to be ranked fundamental, unquote. On the other hand, rights such as freedom of thought and speech were of the very essence of a scheme of ordered liberty because they constituted, quote, the matrix. Boy, the matrix, huh? The indispensable condition of nearly every other form of freedom, unquote. So says Henry J. Abraham in his book, Freedom and the Court, Civil Rights and Liberties in the United States, 5th edition, Oxford University Press. Well, Oxford, that tells you a lot right there. What else have we got on ordered liberty? Okay, here's Burke. He's one of our historical thinkers on the conservative side. Let's see what he says. Edmund Burke is rightly renowned as the father of conservatism. In this bicentennial year of his death, that was 2017, we do well to recall that Burke was also a champion of ordered liberty, a practical politician and statesman, as well as a profound philosopher skilled alike in writing and oratory. Burke devoted his public life to defending natural rights and liberties and battling arbitrary government in America, Ireland, India, and most famously, France. Burke was born in Dublin, educated at Trinity College. After studying law for 2 years, he went to the Middle Temple in London to complete preparation for the bar, but forsook law, opting to become a man of letters. Wow, I would like to be a man of letters. What does it pay? What's the pay for a man of letters these days? Because I think I'd like to have that job. All right. Natural law philosophy, and looks like it's a little bit too intense for me to get too much into it without having read it beforehand. But let's see. The coercive authority of the state is limited to what is necessary for its existence. To this belongs the whole order of criminal law. It considers as crimes, that is, the object of punishment, trespasses against those rules for which society was instituted. The law punishes delinquents not because they are not good men, but because they are intolerably wicked. It does bear and must bear with the vices and the follies of men until they actually strike at the root of order. Okay, so he's saying there are bad people out there, but we don't punish them just because they're bad, but because they do wicked things. And we have to bear their insolence, wickedness, until they actually do something. Okay. Well, I think I will leave Mr. Burke to another day. Let's find another opinion. Hmm. Ordered Liberty, a book in by James E. Fleming over here at Amazon. Many have argued in recent years that the U.S. constitutional system exalts individual rights over responsibilities, virtues, and the common good. Answering the charges against liberal theories of rights, James Fleming and Linda McLean develop and defend a civic liberalism that takes responsibilities and virtues as well as rights seriously. They provide an account of ordered liberty that protects basic liberties stringently, but not absolutely, and permits government to encourage responsibility and inculcate civic virtues without sacrificing personal autonomy to collective determination. Personal autonomy. I like that phrase. That's what I think we all are entitled to. And that does there a constitutional provision that protects personal autonomy? Hmm. Wow. Maybe there's not one. Do you have any idea where we could find, after this court decision, can we find a basis for personal autonomy? That's what I think is really behind my concerns here. I am happy that citizens of states are going to have to be engaged in the debate over abortion. I would be less happy if the Supreme Court had just said, well, we in our wisdom are going to, cut the Gordian knot and say, all right, it's instead of 15 or 24, it's now going to be, let's say, throw a dart at the dartboard and say, oh, okay, how about 18? And then pursue and then pretend that that somehow was the supreme law of the land just because they are so wise that they knew how to pitch that dart to know that it would land on the right number. No, I'm glad they didn't do that, and I'm glad to see that citizens are going to have to be citizens and stand up. And you know, now on the other hand, is this a kind of a divisive decision that some people are going to use to try to break up the country? To say, I'm not going to go to Arizona anymore because they have a strict abortion, but I'm happy to go to Massachusetts because they're is liberal. And you know, it does tend to disintegrate the unity of our country when our one of these most basic healthcare decisions is now going to be distributed over 50 states, and that is going to be very, very interesting as well as, but it's going to get people involved, and perhaps this might actually bring people to attention to the fact that our institutions are being encircled in 8-foot fences with razor wire on them, and the people's house is inaccessible. You have to make an appointment and go through the metal detector, and the the access of the people to our institutions needs to be restored. So if you feel you've got a strong argument, you have a way to do it. This fortress mentality that has been imposed on us by the Democratic administration, by Biden, is the enemy of the people that would like to see the Constitution as protecting that right to, if not a right to abortion, let's just say a right to personal autonomy to make your own decisions, or else let's just pick up a sign that says our bodies ourselves and march around the big barriers and the Jersey walls and the chain link fences with razor wire trying to be heard. Oh, sorry, we had a troll there. I think I just got rid of him. There's another one. All right, you guys, if you see a troll, just please write the word troll on your screen, and I'll zap him for us. Oh, there's another one. Oops, oops, I just there block user. There you go. Yeah, we rarely do have any trolls here, so all right. Well, we are not interested in anybody's personal lives. Does not merit any discussion on our YouTube. And Jimmy, no, I'm usually not on during the weekends, and I used to be. I used to do 11 or 12 shows a week, and now I'm glad to just be doing one a day. Just need to back down a little bit, and I've spent most of my time researching, watching the war, all of that. Oh gosh, there's another one. They keep coming back. Yeah. All right. Yep. Everybody's a gentleman here, and everybody is worthy of personal autonomy, right? All right, that's basically my show for this morning. I wanted to emphasize what I see as the hidden part of this decision, which is taking away our constitutional right of privacy, which was implied from other constitutional provisions by the liberal courts of the 60s, and now 50 years later has been quashed and denied and apparently no longer exists under the Constitution. Your rights of privacy are now your business. You take care of it with your legislature. I'll take care of it with my legislature. And hopefully we'll come to a just result that will protect everybody's personal autonomy, right to make your own decisions, and the privacy between you and your healthcare providers. All right. Oh, somebody's gotten really excited here. Probably has 17 different names that he can go under at once. And all right. Well, at any rate, good time to end the show because I'm done. Have a good day, guys.